So continuing on, I'm on page 14 and I'm on option 2 of potential remedy for this declaratory judgment as like what I would like to see as a final outcome. So for option 2, I did not put much. Option 2, there are other options, but they can be discussed during these proceedings. Other options are not preferred by petitioner. So basically what I'm saying, my preference is for the state to step in, however necessary, to administrate their property, the name, under the rule of usufruct. Finally, and as I continue with this narrative, finally, we, each one of us, have been promised life and life abundantly by our Creator. And it appears that we, as a collective, choose second, third, or 10th best. Petitioner does not accept this at all. Petitioner has no desire to participate in deception, trickery, or misrepresentations against anyone, as petitioner attempts to see everyone as petitioner's brother or sister, and God, the Creator of all, as our Father. Each of the created has a divine spark of the Creator and therefore is subject to the royal law of the Creator. We, as the created, are to act and do accordingly as commanded. If one of the created violates the royal law against another fragmented part of the creation, ultimately the scales of justice must balance out. It is commonly referred to as the law of cause and effect. Petitioner is not asking to have divulged national security secrets. Petitioner does not seek anything of the respondents and this Supreme Court other than what petitioner understands to be evidenced and required by law. Our respondents, as public officers or trustees required by law to administrate property belonging by the state under the rule of usufruct, since it appears a man has been left spoliated and or naked, where everything done in the name he uses vests to benefit the state. Petitioner believes there can be no reasonable legal excuse not to address this matter, particularly in camera, meaning in private, due to the fact that petitioner mentions any federal issues as the birth registration was received and accepted at the state of New York level. This birth registration appears to have created a registered organization, a state, person, individual, etc. Petitioner is simply looking for answers from the respondents and this court to address what has been questioned, which had been ignored previously by public trustees or officers. Once these various issues are addressed and relief provided, petitioner believes he can move on with his life, liberty, and the pursuit of happiness. Petitioner prefers not to travel unless necessary, as this would create a hardship to the state of New York to have this matter adjudicated. Petitioner believes that this discussion or process can be adequately accomplished in writing and at some point by telephone. In any court proceeding, petitioner cannot swear to tell the whole truth and nothing but the truth because petitioner does not know the whole truth, and this is the main cause for this exercise. However, respondents and the Supreme Court do have the answers to petitioner's questions. Petitioner cannot make a claim to the name as it appears from all evidence appearing. The state of New York is the title holder and owner of the name Anthony Rubio. For the petitioner to make such a false claim to state's property or to have the public officers allow petitioner to make such a false claim would seem to be not honorable upon petitioners, the courts, or respondents' part. It would appear to force petitioner to do so would be asking petitioner to commit a felony by claiming to be a false personation, or worse, warring against the United States as a belligerent act. Petitioner also believes that this court may be asking petitioner to engage in the unauthorized practice of law, attempting to represent a person without authority or bar a license to do so. How do you like that one? The purpose of this exercise is for respondents and this court to clarify, explain, instruct, and advise petitioner how that petitioner may use, without personal liability, a state of New York registered organization properly, and in the meantime help the United States and future generations. Petitioner believes the Supreme Court will not deny this administrative due process of law based upon a man requiring answers to these important questions. The evidence remains that petitioner is the authorized exclusive user of the name, person, estate, individual, etc., Anthony Rubio, and all derivations thereof, since the state of New York, through its authorized public officers, intentionally sent and provided petitioner said birth document or instrument for the ultimate benefit of the state of New York. Proper service of process has been achieved in accordance with due process and provisions of statutes concerning entities, artificial persons, and registered agents petitioner believes, so that petitioner can be in honor. All parties have been given notice of this action by petitioner and this court. And then I sign it, I am from the pre-existent father, a son in the pre-existent one. And again, I put the white peace flag on the signature line along with the footprints, and then how I would sign it is by Anthony, for Anthony Rubio, authorized signature, property of state of New York. And then the petitioner with the address and all the respondents, Mark Fleischer, Director, Bureau of Administrative Hearings, which of course I did not realize Mark Fleischer was no longer there. The phone number, the fax number, and I added Andrew Como, the phone number, address, and then Thomas DiNapoli, phone number, fax, address, and then Eric Schneiderman, phone number, fax, and etc. So what happened, previously I had sent to Mark Fleischer, who's with the Bureau of Administrative Hearings. This now all goes to the fact that I've done all these exercises previously. The first Exhibit A was to send this up to Andrew Como and Thomas and Eric, and I believe this was the fax, yes. And I put, Dear Public Officer, Official, Trustee, please see the attached copy of the correspondence delivered by registered mail RA 757929199 US to Mark Fleischer with the title Director of Bureau of Administrative Hearings, Division of Legal Affairs, Department of Health, State of New York, on March 20th, 2015 at 9:54 a.m. The purpose of sending you a copy of this demand for administrative hearing to adjudicate the rights, duties, and obligations of a man to an individual birth estate organized and held in trust by the State of New York Department of Vital Statistics is to provide you notice in your official capacity. The fax confirmation receipt shall serve as evidence of delivery. Total pages, including this transmittal sheet, 9. Thank you and may God bless you. So, dated April 20th, fax transmittal, total pages 15. Dear Mark, Andrew, Thomas, and Eric, please forgive the delay for not getting this to you sooner, as I have been busy. Please see attached notice of default, acceptance of dishonor. Hold on.